Yes. Hello. Good evening, everyone. Good evening, everyone, and welcome to Everything Legal Lounge. Welcome to Everything Legal Lounge. Okay. Yes. Good evening, everyone. Welcome to Everything Legal Lounge. Um, Legal Lounge. Yes. So before we begin, first I will talk briefly about our platform, EL Everything Legal. This live is powered by EL Everything Legal. Now, Everything Legal is an education platform. I repeat, Everything Legal is an education platform built purposely to enable the students of the Nigerian Law School understand basic concepts for the bar exam, apply these concepts in these topics, and pass the bar exam in flying colors. So basically, what we are trying to do here is to make students understand the concepts, not just understanding, applying these concepts in scenario questions to enable students pass the bar exam. And this is what we do in EL Everything Legal. Now, for this platform themed Everything Legal Lounge. Legal Lounge is a free platform open to students of the Nigerian Law School to allow them participate in what we do and take part in a free platform like this, geared towards enhancing success in the bar exam. I repeat, geared towards enhancing success in the bar exam. Now, for this section, this will be an introductory section. And in today's night section, which we'll be holding every weekend from today, commencing today. For today's night section, we would deal with certain issues in the course property law practice. Property law practice is one of the 5 courses offered in the Nigerian Law School. So to be called to the Nigerian bar, you must write and pass property law practice among other courses in the Nigerian Law School. We picked property law practice today because property law practice looks easy on the surface. Property law practice looks easy on the surface, but it is indeed a technical course. I repeat, property law practice looks easy on the surface, but it is indeed a technical course. There are basic concepts students must understand and apply to approach property law practice in the bar exam. Approach property law practice in the bar exam. So basically, that's what we'll be doing today to introduce Everything Legal Lounge. And don't forget, my name is Chukwemeka Philip Esq. I'm a legal practitioner in Nigeria and the founder of EL Everything Legal. Now, without wasting much of our time, having had a good introduction, let's get the business of the day. The business of the day is demystifying and understanding property law practice. So today we are going to demystify property law practice as a course in the Nigerian Law School to understand these concepts and apply them in the bar exam. Basically, the problem students have in the bar exam is not reading. The Nigerian law school is structured in a way that the moment you get admitted in the law school, you start reading immediately. Yes, even the laziest of students, in quotes, laziest in quotes, always read in the law school because of the environment. So basically, the problem is not reading, and it's not because of reading students don't make it in the bar exam. No, it's a different thing altogether. At night reading, there is an issue of understanding, one, and there is another issue of applying the concept in painted scenario. In fact, application is where the major problem is. I repeat, application is where the major problem is. As students, you can testify to this. You must have read certain topics for arts. And when you see a question, you feel like you've not seen that topic before, and you look lost. And in fact, it may weigh some students down because they feel that all the effort they've been putting into reading has been in vain. But no, that's not the problem. The problem is not your inability to read. The problem is understanding and applying basic concepts in painted scenario. That is what you'll be tested on in the exam. Now, in our subsequent classes, we'll provide tips to understand and apply basic concepts in the bar exam, and we'll also provide materials to enable you understand how to answer questions in bar exam, to enable you understand how to answer questions in the bar exam, because that is where the problem is. Now, let's get back to the issue for today, property law practice. Before we get to property law practice, to answer questions in the bar exam generally for the 5 courses, you need to know this. As a student in preparation for the bar exam, you would be tested on the position of the law. I repeat, you will be tested on the position of the law, also known as legal principles. So the scenarios painted are painted from legal principles you've learned. That's why I said the problem is application. Let's take, for instance, let's delve to criminal litigation. In criminal litigation, there is a topic called arrest and search. Now, in that topic, arrest and search, you would be taught the modes of executing a warrant of arrest. In other words, how can we arrest a suspect? That's what it means to execute a warrant of arrest. Now, appropriate execution of warrant of arrest depends on the time and the location. Listen, it depends on the time and the location. You must identify whether we are in Lagos, Abuja, or Kano, right? And also look at the time the arrest was executed. Now, we all know that in Lagos, I repeat, we all know that in Lagos, arrest cannot be made inside the courtroom under section 27 of the ACJL Lagos. Arrest cannot be executed inside the courtroom. Inside the courtroom, right? Now, if there is a scenario, or the scenario will come like this: Mr. Ali, a suspect, was arrested by Corporal P, a police officer, in the Ikeja High Court, Court 5. And the question will be, what is the propriety or otherwise of the arrest? Now, before you answer that question, you have to go back to the principle of arrest you have learned. That is the position of Lagos, that arrest cannot be executed in the courtroom. And the answer will be this: the arrest of Mr. A is inappropriate. The position of the law is arrests cannot be appropriately executed in the courtroom in Lagos State. And you back it up with an authority, Section 27 of the ACJL, Lagos. Now, this is what answering questions in the bar exam is all about. You must understand the position of the law and apply it. Understand the position of the law and apply it. Now, class, you would always be tested on the position of the law. Following that arrest, in Abuja, the position is different. In Abuja, the position is different. In Abuja, arrest can be made in the courtroom, but not when the court is sitting. And we all know that the court sits at 9 a.m. So in Abuja, a scenario will be painted that arrest was made at 8:30 a.m. inside the courtroom. And you'll be asked the same question, what is the propriety or otherwise? Now, in application of your principle, you must have understood that in Abuja, arrest can be made in the courtroom, but not when the court is sitting. So arrest made by 8:30 a.m. inside the courtroom is appropriate in Abuja, but it is not appropriate in Lagos State. These are the issues you need to take into cognizance in the 5 courses, not just criminal litigation alone. I was saying that you have to have a good mastery of application of the position of the law. Now, let's get to our agenda, the main focus for today, which is demystifying property law practice. Demystifying property law practice. Now, the closest you may have done before the law school in property law practice is known as land law. It's known as land law, right? But for the law school, we are concerned with property law practice. The practice there is important because we are concerned with procedural laws and not just the theoretical aspects. In land law, you learned the theory. In property law, we have to learn the procedures. That's why it's called property law practice, right? Now, for the course property law practice, before we attempt any question, any scenario in property law practice, there are basic factors that must be established by you, the students. I repeat, before you attempt any question in property law practice, there are basic factors that must be established. And it is this factor we would learn, understand, and apply today. I repeat, we will learn these factors, we would understand these factors, and we would apply these factors today. Property law practice. Now, I would paint a random scenario in property law. A random scenario will be painted, and this is the line of the questions. Number 1, identify the transactions. Listen carefully. The line of the questions are as follows. Number 1, identify the transactions in the scenario. Number 2, identify the documents or the instruments to be executed. Number 3, who are the parties to the transaction? Number 4, who prepares the legal instrument or instrument? Number 4, who prepares the legal instruments? Now, having attempted these 4 questions, the next set of questions will come from drafting the documents. And basically, in drafting, you'll be asked to draft either the introductory part or the concluding part. especially for property law practice. It will be focused on draft, the introductory parts of the document to be executed, or draft the concluding part of the document to be executed. However, let's delve a little. There are certain documents that you will likely be asked to draft in full, and you must learn how to draft them in full. One of the documents is power of attorney. One of the documents is power of attorney. And another one, another legal instrument is will. Yes. One is power of attorney, another is will. You see these two documents, you have to learn how to draft them in full because you'll be likely tested in full documents. But for other documents like deed, that's deed of lease, deed of sublease, deed of assignment, you'll be asked to draft those in parts, right? So these are the line of questions. After drafting, then any other question that would follow will be from a particular principle in that transaction. Now, having understood the line of question, watch the line of question again. Identify the transactions between the part in the scenario. The second one, identify the documents or the legal instruments to be executed. Number three, who are the parties to the transaction? Number four, who prepares the legal instrument? Number five, draft the introductory part or draft the concluding part. Then from 6 and 7, you may be tested on other basic position of the law in each of these courses. Having known this line of questioning, let's get to the factors you must establish, you must understand in a scenario before attempting any question on property law practice. Yes, if you are writing, you can write. What I'm about to give you now is very important. So let's begin with the first factor. The first factor to deal with in a scenario, these things are what you will deal with before attempting the questions. These are the things you must establish by yourself before attempting the questions. Now, the first one you must establish is called property jurisdiction. If we don't want to use the word property jurisdiction, we can say the location of the property. I repeat, property jurisdiction or the location of the property. Now, jurisdiction, the use of jurisdiction here is not the use of jurisdiction in civil litigation. Let's not get it twisted. The use of jurisdiction here simply means an area that covers basic locations. Areas that covers basic locations. So jurisdiction here is not the right or the authority of a court to hear and decide a matter. That is not the jurisdiction we are referring to in property law practice. Property jurisdiction is simply where the property is situated, where the land is located. You must establish that first. Now, to understand the application, you see, we don't just learn. We learn, we understand, and apply. Now, to understand the application of property jurisdiction or location, we have to take cognizance of two laws. I repeat, to understand the application of property jurisdiction or the location of the property, we have to take cognizance of two basic laws. The first law is the Conveyancing Act. The first one is the Conveyancing Act, and the second one is the Property and Conveyancing Law, PCL. I repeat, the first one is the Conveyancing Act. The second one is the Property and Conveyancing Law, PCL. These are the two laws you must understand to apply location in a scenario. This is what we mean. For location, there are three locations we are concerned with. with respect to property law practice. The first location or jurisdiction is the Conveyancing Act states, CA states. The law, the statute is known as the Conveyancing Act. However, there are states in Nigeria that this Conveyancing Act covers. So any state under this Conveyancing Act are known as CA states. CA states from the Statute Conveyancing Act. The second one is PCL states. PCL states from the Statute Property and Conveyancing Law. So there are various states in Nigeria that are covered by Property and Conveyancing Law, PCL states. The third one is Lagos. The third one is Lagos. If you watch me closely, I did not say MPL. A lot of students want to use MPL. Now, MPL is simply Mortgage and Property Law of Lagos. So MPL covers the mortgage transaction alone. In application for jurisdiction, we say Lagos as a jurisdiction, as a location, and not MPL, because MPL applies to only one transaction. So I repeat, for location, there are three. The first one is CA states from the Conveyancing Act. The second one is PCL states from the Property and Conveyancing Law. The third one is Lagos. Now, let's begin with CA states. I repeat, all these are states in Nigeria, but some states in Nigeria are covered by CA, while some states in Nigeria are covered by PCL, and the rest, the last one is Lagos. Lagos is a jurisdiction on its own because Lagos have basic different concepts with respect to property transaction. Now, for the CA states, the states in Nigeria that are under CA states, number one, all the northern states. I repeat, all the northern states. When you see a state in a scenario, the first thing you should identify is this state in the north? Is this state in the southeast? Is this state in the south-south or the southwest, right? So number one, for CA, all the northern states, including North Central, North Central like Nasarawa State, Kogi State, Benue State, and Kwara State. Yes, these are CA states. Northern states. Number two, all the southeast states. That's the Igbo-speaking states. Enugu, Imo State, Anambra State, Abia State, Ebonyi State. The southeast. Number three, the south-south, except Edo and Delta. So states in Nigeria covered by CA are the northern states, the southeast, and the south-south, except Edo State and Delta State. The south-south, that's the Niger Delta region, right? Rivers, Cross River, Akwa Ibom, Edo State, Delta State, all these are south-south states. But however, in the south-south, we must exclude Edo and Delta states. We must exclude Edo and Delta states. The comment section is open. Please, in course of this class, feel free to drop emojis, questions, and if you are following, drop all that in the comment section. We can see them from this end. Now, we've dealt with CA states as a location. The north, the southeast, the south-south, except Edo State and Delta State. Now let's get to PCL. For the PCL states, number one is the southwest. I repeat, number one is the southwest, except Lagos State. I repeat, number one, southwest, except Lagos State. I say Southwest, I mean those Yoruba speaking states that start from OOO, right? They are always O, Oyo, Oshun, Ondo, you understand, right? Ekiti, they start from OOO, the Southwest, the core Yoruba speaking state. They are PCL states apart from Lagos. Now, in the PCL states, we must include Edo and Delta states. Edo and Delta states falls under the PCL. And then the Southwestern states, that's the Yoruba speaking states, the ones that start from O, the O's, you know, they fall under PCL, but you must exclude Lagos State. You must exclude Lagos State. Now, the third one is Lagos. Lagos is a jurisdiction on its own. Lagos is its own. So this is the first thing to achieve in in a scenario. You must deal with the issue of property jurisdiction or location. Having dealt with this, the second thing you have to deal with in a scenario is nature of interest. I repeat, the second thing you have to deal with in a scenario is nature of interest. Is nature of interest. Class, you must identify the interest covering a land. I repeat, you must identify the interest covering a land. And for nature of interest, they are divided into two. For nature of interest, they are divided into two. The first one is freehold interest, and the second one is leasehold interest. I repeat, the first one is freehold interest, and the second one is leasehold interest. Yes, that's great, Olamide. We're happy you are enjoying this. There are more to come. Now, in the nature of interest, we'll start with freehold interest. We don't need to spend too much time on nature of interest. There are things you should look for in a scenario to apply your understanding. Now, to identify that the nature of interest is freehold interest, the land in question will be covered by right of occupancy. I repeat, the land in question will be covered by right of occupancy. Where the land is covered by right of occupancy, the nature of interest is freehold interest. Where the land is covered by right of occupancy, the nature of interest is freehold interest. Now, for freehold interest, the owner of such land has absolute interest in the land, and the interest does not revert back to the state. For freehold interest, there is no reversionary interest to the state. And this freehold interest occurred mainly before the enactment of the Land Use Act. The issue of having absolute interest in a land happened where persons acquired land in Nigeria before the enactment of the Land Use Act of 1978. So where the land is covered by right of occupancy, the owner of that land has absolute interest in the land, and the state government has no reversionary interest on that land. The state government has no reversionary interest on that land, right? So that is freehold interest. That is freehold interest, right of occupancy. Now, where the land in question is covered by certificate of occupancy, where the land in question is covered by certificate of occupancy, the nature of interest is leasehold interest. Where the land in question is covered by certificate of occupancy, the nature of interest is leasehold interest. Now, The certificate of occupancy is issued by the government. Listen, the certificate of occupancy is issued by the government. Where the government issues certificate of occupancy on a particular land, it means that the owner of such land has no absolute interest in the land. There is still reversionary interest owned by the state government. I repeat, where a land is covered by certificate of occupancy, the nature of interest is leasehold interest, because certificate of occupancy is issued by the state government, indicating that the state government has reversionary interest on that land. Now, when a person acquires a land that is covered by certificate of occupancy, the person is the owner of the land, but technically there is an existing lease on that land. The lease is between the state government and the owner of the land. Listen, you acquire a land covered by certificate of occupancy, it means that there is an existing lease between you, the owner of the land, and the state government. That's why you see in some textbooks that the state government is the head lessor. The state government is the head lessor. Now, because of the existing lease, the state government still has reversionary interest in that land, and it's usually 99 years. After 99 years, the interest reverts back to the state government. So you can see technically the owner has ownership of the land, but it is a lease for a period of 99 years. After 99 years, the reversionary interest goes to who? To the state government. That's why where a land is covered by certificate of occupancy, the nature of interest is leasehold interest, because there's an existing lease between the owner of the land and the absolute owner, who is the state government. I believe we are following and we understand the concept of nature of interest. So for the question I saw now from Faustina, yes, freehold interest, what you should look out for in a scenario for application now, you need not stress yourself. What you should look out for in a scenario to identify whether the nature of interest is freehold interest or leasehold interest is of occupancy. Read the scenario very well. Look at the location of the land. You see questions like this. The land is situated at number 22 or plot 111, Saudi Arabia Street, Ikeja, Lagos, covered by certificate of occupancy number M/N/222, right? Now, as a smart student, you have to underline the fact that that land is covered by certificate of occupancy. When you see that the land in question is covered by certificate of occupancy, the nature of interest is leasehold interest. And in this scenario, if you don't see that the land is covered by certificate of occupancy, the nature of interest is freehold interest. Yes. So to save yourself the stress, just look out for the word certificate of occupancy. If you see that the land is covered by certificate of occupancy, underline that. As a smart student, it indicates the interest is leasehold interest. And if you don't see certificate of occupancy, you don't need to stress yourself. The interest is automatically freehold interest. I believe I've answered your question at this point. Yes, so that should work for your application in a scenario. Look out for certificate of occupancy. If you see it, underline it. It's pointing to leasehold interest. If you don't see the land is covered by certificate of occupancy, you should know that the nature of interest is freehold interest. This will save you a lot in the bar exam, especially for the transaction lease. When you get to this, your understanding of nature of interest would differentiate a student that have been reading from the students that have understood and is able to apply these concepts in painted scenarios. So yes, I believe we've dealt with the second factor, which is nature of interest. Freehold interest, leasehold interest. Just watch out for the land covered by certificate of occupancy. If the land is covered by certificate of occupancy, the nature of interest is leasehold interest. If you don't see certificate of occupancy, the nature of interest is freehold interest. Now let's get to the third factor you must establish in property law practice, and that is transactions. In fact, this is very important for the bar exam. You see, if the only thing, I'm not advising you to be lazy as students, please, but if the only thing you are able to grab in property law practice is transactions, you understand all the transactions you need, I bet you would not fail the bar exam for property law practice. If you understand transactions very well, you would have no problem in the bar exam. Yes, I said that. Property law practice is all about transactions. Yes, there are other incidental matters. Mind you, there are incidental matters or incidental topics that are not transactions. But the bulk of your work in property law practice is on transactions. And as students preparing for the bar exam, you'll be tested on transactions. You must not just read and understand. You must be able to apply transactions in scenario, and you must be able to draft the documents in this transaction. So the third factor you must identify in a scenario for property law practice is transactions. Transactions are important as anything you can think of in property law. You must have a mastery of transactions. I know why I'm stressing on transactions. When you get to the exam hall, what will be flying around is identify transaction. What's the transaction between A and B? What's the transaction between Adamu and Aisha? What's the transaction between Eze and Mazi Okeke? What's the transaction between First Bank PLC? Yes, banks, artificial persons can be parties in transaction. Be careful. You'll be what's the transaction between First Bank PLC and Olamide, right? You would be tested on transaction. You cannot afford not to master the application, not just reading, the application of transactions. Now, in property law, there are a lot of transactions. There are a lot of transactions. But as a smart student, we have to look at your course outline, the topics you have been doing so far. If you follow closely on the topics you've been studying so far in property law practice, at this point, your exams is in December, so you must have, in fact, gotten to the last aspect of property law. And at this point, you must have dealt with all the important transactions. So if you follow closely in the topics you have been learning so far in the law school, as a smart student, you would figure out that you are concerned with just 4 transactions. I repeat, if you follow the course outline, your learning outcomes, and what you've been doing so far in property law practice, you will find out that you are concerned and you'll be tested majorly on 4 transactions. Now, what are these 4 transactions? You can write. Number 1, the first transaction you'll be tested on is donation of power. Class, I did not say power of attorney. I said donation of power. There is difference between a transaction and a document or instrument to be executed. Listen carefully. I said donation of power. I did not say power of attorney. The transaction is donation of power. Power of attorney is not a transaction. Yes, in the law school, when you were taught the topic, I think is it week 3 or week 4, the topic is power of attorney. And when you are asked, identify the transaction, a student that has not been able to apply your understanding would quickly write the transaction is power of attorney. And if you write that the transaction is power of attorney, you'll be wrong. You would miss that question. I'll be wondering, I read this thing, I know it very well. How did I fail? Now, this is why you fail. This was not you. Yes, it cannot be you because you cannot follow our classes and fail. We don't have students that fail, right? Yes, it cannot be you, but this is why students miss it, or this is why property law practice is technical. You learned the topic as power of attorney, but the transaction is not power of attorney. The transaction is donation of power. The transaction is donation of power. It's when you are asked the document, that's when you write power of attorney. So power of attorney is a document to be executed and not a transaction. The transaction is donation of power. So let's list the 4 transactions, the basic 4 you must learn, understand, and apply. So the first one is donation of power. The first transaction is donation of power. The second one, the second transaction is sale of land. I repeat, the second transaction is sale of land. Sale of land. The third transaction, number 3, the third transaction is lease. 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 The third transaction is lease. Now, the fourth transaction is mortgage. The fourth transaction is mortgage. These are, if you follow your topics, you find out that these are the first 4 topics you were taught in the Nigerian law school. The 4 important transactions are 1, donation of power, 2, sale of land, 3, lease, and 4, mortgage. You will be tested on these 4 transactions. And you must be careful because one scenario can spin 2 or 3. In a scenario can include both donation of power, lease, and mortgage. A scenario can even include the 4, donation of power, lease, sale of land, and mortgage. And you'll be tested in all these areas. But you'll be asked, what is the transaction between A and B in that scenario? And they'll say, what is the transaction between E and F? You should know that the transaction between A and B is different from the transaction between Mr. E and F. They are very confusing. They are not as straightforward as you think. This is one of the reasons students have problem with property law practice. Property law practice looks simple when you are taught, but there is more to a technical application of this course. So I repeat, the 4 important transactions are donation of power, sale of land, lease, and mortgage. And for this class, we would examine these 4 transactions, and I'll give you basic hacks, basic tips you must understand to apply in your scenario. Now, there are other transactions. There are other transactions like gift of land, pledge of land, and so on and so forth. There are a lot of transactions. For the exams, you are concerned with 4 basic transactions. This is how you should read smartly and pick out important points you'll be tested on in these transactions. So let's start with the first one. The first transaction is donation of power. I'll do something for you in this class. For each transaction, I will tell you how to identify them in the scenario, the documents that will be executed, the parties to the transaction, and then finally, I'll tell you the solicitor that prepares the document. Yes, for these 4 transactions, I will tell you how to identify in the scenario because you must apply. That's the first issue. The second is the document or the legal instruments to be executed. The third one the parties to the transaction. The fourth one, the solicitor that prepares the transaction. We'll examine these key issues in each transaction. Now, the first is donation of power. The first is donation of power. If you follow closely, you'll not be asked to define concepts in the bar exam. The bar exam is different from faculty of law. Your answers are straight to the point answers, go basically to the position of the law. Or if there's an exception, you write both the position of the law and the exception and back it up with an authority. In 4 or 5 lines, you are done with a particular answer. When you see in a question, in a particular question, you are writing 10 lines. My friends, you are likely going out of point. Respectfully, when you are writing up to 10, 12 lines for number 1A or 1B, you are writing 12 lines. You are going out of point. This is not faculty of law. This is law school. And in law school, you are tested on basic position. So go straight to the position of the law. Go straight to the position of the law and back it up with an authority. If there's an exception, you can include the exception. As I said, I would still give more hints and more things on how to answer questions in the bar exam. Now, for the first transaction, donation of power. For the first transaction, donation of power. This is the idea you must have for donation of power. You are not to define, you are to identify in a scenario. In a scenario where Mr. A has the ability to perform a transaction, listen carefully. In the scenario, Mr. A has the ability, has all it takes to legally enter and perform a transaction. But for one reason or the other, he is unable to perform the transaction at that particular time. Mr. A has to perform a transaction. He has all rights. He has the capacity to enter into the transaction and perform the property transaction. But for one reason or the other, he is unable to perform the transaction at that particular time. And he needs the transaction to be performed in his absence. Listen, let's bring it down to something basic. This is a bottle of water, right? I need a bottle of water. I have money to get a bottle of water, in fact, a pack, if I so wish, right? But at the moment, I am in a class. I cannot stand up to go to a kiosk to get a bottle of water. And I need this bottle of water at this moment. What am I to do? I'm to find another person that can get this bottle of water for me on my behalf. This does not mean I cannot do it. This does not mean I don't have the money to buy the water or I don't have the capacity to purchase it. The issue with donation of power is that for one reason or the other, at that moment, I am restricted. I am unable to do this. And I want this to be done. I need this water. I need to get it. What I'll simply do is to find another person that will purchase this water on my behalf and in my name. That's the basic idea behind donation of power. Mr. A can lawfully enter into this transaction. Mr. A can lawfully buy this land. He can lawfully sell this land. But for one reason or the other, he is unavailable. He is restricted. But the transaction needs to go on in his absence. He needs to sell the land when he's not around. What Mr. A would do is to donate his power to sell that land to another person. Appoint another person to perform the transaction of sale of land on his behalf. That is the idea behind donation of power. These are the things you should look out for to apply donation of power in a scenario. I can lawfully do this. It must be a lawful act. In our class, in our master class, I told my students, you cannot donate power to steal, kill, and destroy. You are not the devil, right? Now, the act to be done must be a lawful act. And streamline this to property law practice, it is a transaction. It is a transaction, right? So this is what you need to understand and apply in a scenario to identify donation of power. So you see concepts like Mr. A fell sick and he desires to continue the sale of land transaction in his absence. Or Mr. A has an appointment with the president. Or Mr. A got appointed as the special advisor. Or Mr. A had an accident and is receiving treatment in the hospital. Or Mr. A is processing his visa and wants to travel out of the country. And he desires that the transaction goes on in his absence. What you advise is that you advise him to donate his power. And if such a scenario is painted and you're asked what is the transaction, you have to answer that the transaction is donation of power. So you see basic keywords like delegate, authorize, gave instruction to, donated his power, authority in writing, and basic concepts like that, pointing towards one thing. Somebody needs another person to carry out transaction on his behalf. That's the idea behind donation of power. So the transaction is donation of power. The transaction is donation of power. Now, the document to be executed, listen carefully. The document to be executed is a power of attorney. The document to be executed is a power of attorney. This is why I told you that if you answer transaction as power of attorney, you would miss that question. Power of attorney is not a transaction. Power of attorney is a document. Power of attorney is a document. Power of attorney is not a transaction. So now the transaction is power of attorney. And the document to be, the transaction, sorry, is donation of power. That was an oversight. The transaction is donation of power, while the document to be executed is power of attorney. Now, the next issue is, who are the parties to the transaction? Now, in power, the parties are the donor and the donee. The donor and the donee. The donor is the one giving authority, giving instruction, authorizing another person to perform transaction on his behalf. The donee is the one receiving authority, acting on behalf of another person. So the parties are the donor and the donee. The next is the preparation of the document. The document or instrument is power of attorney, and it is prepared by the donor's solicitor. The power of attorney is prepared by the donor's solicitor. I use the term solicitor because another issue is your choice of words. Your choice of words are important to excel in the bar exam. I use solicitor and not lawyer and not legal practitioner, because the job of a solicitor is to prepare legal instruments, documents, and other things. Preparation of documents is the job of a solicitor. The thing is, it's in Nigeria, there is a fusion between the job of a barrister and a solicitor. When you are called to the Nigerian bar, you are a barrister and also a solicitor, right? So you can do the two. But in jurisdictions like the UK, there is a separate office or the separate position for a barrister and a separate one for a solicitor. So you go to a school like law school, to become a solicitor. And you still go to a school like law school in the UK to become a barrister. The barristers are the advocates, the ones that advocate for clients in court. And the solicitors prepares documents. In the UK, the job of a barrister is different from the job of a solicitor. That's why often in Nigerians, you are advised not to refer to yourself as a barrister. Yes. When they are called to bar, I believe most of you will be quick to put beside your name, barrister, barrister Olamide, right? Or barrister Coca, barrister Ade. That's not important, because if you put barrister beside your name, or if you address yourself as a barrister, who becomes a solicitor? Yes, if you are a barrister, then who is a solicitor? Who is the solicitor? So you are a legal practitioner in Nigeria that can practice both as a barrister and a solicitor. That's why you don't call yourself barrister Ade or barrister Obi or barrister Titi, right? So that is, by the way, the document power of attorney is prepared by the donor's solicitor. The donor solicitor. Now, quickly, let's get to the second transaction we are to examine today. The second transaction is sale of land. The second transaction is sale of land. The second transaction is sale of land. I need to tell you something about sale of land. Sale of land is the heart of property law practice. What did I say? Sale of land is the heart. If property law is a human being, sale of land is the heartbeat of property law practice in the Nigerian law school. You can do your research. There is no year in the bar exam that there is property law practice without a touch of sale of land. I repeat, there is no year you would write property law practice, both main exam and receipts. You can check both the main exam and the receipt exam. You cannot write property law practice without a touch of sale of land. I said so. Yes, I said so. Sale of land is the heart of property law practice. And I'm not a soothsayer, but in your exams in December, you would see sale of land. Yes, you will see sale of land. If it doesn't come as a full scenario question, it will be a question in one of your scenarios. You cannot escape sale of land in property law practice. Yes, in our class, we call sale of land the heartbeat of property law. The heart of property law is sale of land. You must be tested on sale of land. Now, for sale of land, you must be careful, because the law school can play a quick one on you on sale of land. Sale of land is very easy to understand. I believe during the lectures, during the class, when it was taught, you could relate, because most of you may have gone into sale of land transaction. You might have owned lands before you go into the law school. You must have purchased a land. You may have worked with a real estate company, or have been involved in sale of land. So when you are being taught sale of land, you enjoy the class. You'll be very happy and you understand. But you must be careful. There is an aspect of application in sale of land. And this is what I would give to you now for free, for free of charge, right? Yes. Now, in sale of land, it is very easy to identify in the scenario. Oh, let me just say barrister sharp. When you are called to bar, don't refer to yourself as barrister sharp. You refer to yourself as sharp, ESQ, right? Not barrister sharp. But then pass the bar exam and become that barrister sharp. I want to see you do that. That's a good one. So back to sale of land. As I was saying, the sale of land transaction is very easy to identify in a scenario. You see keywords like Mr. A transferred his unexpired residue, or you even see the basic words. Mr. A agreed to buy. He sold the land to Mr. A. He bought the land. You understand? Transferred his entire interest in the land. So sale of land, when you see sale of land in the scenario, you would know that this transaction is sale of land. That's the beauty. You would know. You would identify that this transaction is sale of land. So identifying the transaction is not the problem. The issue in sale of land starts from the documents. Yes, the issue with sale of land starts from the document. That's where the problem is. The document. As a smart student preparing for the bar exam, you must know that there are two documents to be executed in a sale of land transaction. I repeat, there are two documents to be executed in a sale of land transaction. And these documents are divided into initial documents and final documents. The documents are divided into initial documents and final documents. So if you watch closely, you would see questions in the scenario. Identify the initial document. What is the final document to be executed? Right? So the issue with sale of land is on the document, and the documents will change the trajectory of your answers, because from the document, the parties are different. You might be asked to draft. If you didn't identify whether it's the initial or the final document, you would miss the question on drafting. You see, the questions are parasitic questions. Parasitic in the sense that the understanding of question 1A would help you to understand 1B, and 1B would help you to understand 1C. So it's very easy to pass and very easy to fail. Yes. So if you start understanding from the beginning, you would get it all right. But if you miss it from the first one, you likely miss the subsequent ones. This is why you must be careful. You don't need to panic for the bar exam. You just need to be prepared. Of course, you should be prayerful. I would advise you to be prayerful. You should be prepared and also be composed. Be prepared, be composed, and get these things. We're not saying these things for you to panic or be afraid. It's for you to understand. If you're having difficulty, you get guidance. There's nothing wrong in getting guidance. You get guidance and understand the application of these concepts so that you can apply these in the scenario. Now, back to sale of land. I said there are two documents, and the documents to be executed are divided into initial document and final documents. So there are three questions that can be asked for documents in sale of land. The first one you likely be asked is, what is the document to be executed? That's the first one. The second one you'll be asked is, identify the initial document. The question may say, what is the initial document to be executed? And finally, the third question on document you'll be asked is, what is the final document to be executed? I repeat, class, you can be asked, what is the document to be executed? You can be asked, what is the initial document to be executed? And you can also be asked, what is the final document to be executed? Now, if you're asked, what is the initial document to be executed? Please write the initial document and the initial document alone. I will tell you the initial document in this class. If the question says, what is the final document to be executed? Please write the final document and move to the next question. I repeat, I will tell you the final document to what? To be executed. I'll tell you the final document. You learn it now. Now, the third one, if the question just says, what is the document? This is where they play the trick. They will not write initial or final. And they may not even add S. You might not see documents with the S. The question may just be, what is the document to be executed? For sale of land, if the question is, what is the document? As a smart student, you have to write that there are two documents to be executed in this transaction. Number one, initial document, you write the initial document. Number two, final document, you write the final document. If you write only one of the documents, your answer is incomplete. I would repeat this again. If the question says, what is the document, and the transaction is sale of land, please write the two. Write both the initial and the final document. If the question is on the initial document alone, write just the initial document. And if the question is, what is the final document, please write only the final document. Now let's get this. The initial document is contract of sale of land. The initial document is what? Contract of sale of land. If you are asked what is the initial document, your answer will be contract of sale of land. Now, the final document is deed of assignment. The final document is deed of assignment. So if you are asked what is the final document, you simply write deed of assignment. I repeat, if you are just asked what is the final document, you'd simply write deed of assignment. So the final document is deed of assignment. Now, if the question does not specify, the question says, what is the document to be executed? As a smart student, you have to write the two. You say the documents to be executed in this transaction are, number one, contract of sale of land. Number two, deed of assignment. I believe you've learned something new today. Right? So this is the application part of sale of land transaction. You see, let's take it back, and all these are pointing to the same transaction. To complete sale of land transaction, two documents must be executed, both the initial document, contract of sale of land, and the final document, deed of assignment. The closest to this is back to your university days. When you finish or you completed your university, your 5 years in the university, there are two documents you were issued, if you can remember clearly. The first one you were given by your university is the statement of results. You were first issued statement of results by your university. The statement of results is showing that you have completed successfully your LLB program with the university. Now, but with the statement of results, your business is not complete. There is one more document, a final document that the university must give you to show completion of business with the university. And the second document you'll be issued is the certificate. So you'll first be given the statement of results, and second, you'll be given the certificate, right? And these two documents are pointing to the fact that you've completed the business with the school. So basically, this is the issue with documents in sale of land. You must be careful. The reason is this: the question on documents would affect other questions that follow, right? Now, let's begin with the initial document. For the initial document, contract of sale. For the initial document, contract of sale of land, the parties are the vendor and the purchaser. So after you've identified the initial document as contract of sale of land, the next question is the parties. And the parties here are vendor and purchaser. Please, I did not say buyer and seller. Your choice of word is important. I not use the concept of buyer and seller. Don't write buyer and seller in your exam. Write vendor and purchaser. So for the initial document, the parties are vendor and purchaser, not buyer and seller. Now, last day in course of our classes, we had one funny concept. The concept was vendor and vendee, but I believe that was a joke. That was a joke, right? So don't fall into the category that would include vendor and vendee as parties in the initial document. No, you see, the property law practice in property law transaction, the parties always end with or and e, right? Mortgagor, mortgagee, licensor, licensee, lessor, lessee, sublessor, sublessee. And you tend to go vendor and vendee. That is very wrong. That will not apply at all. And I believe that was on the lighter note, right? So the parties are the vendor and the purchaser. The vendor and the purchaser. The next is the preparation of the initial document. Now, the initial document is prepared by the vendor's solicitor. Repeat, the initial document is prepared by the vendor's solicitor. The initial document is prepared by the vendor's solicitor, right? And then finally, as a bonus on initial document, you should know that for stamp duty, the stamp that is paid for the initial document is fixed stamp, is charged at a fixed rate, right? The stamp duty paid for initial document is fixed stamp, right? And it is paid within 40 days. It's fixed stamp and is paid within 40 days. Now, let's get to the final document. The final document is deed of assignment. The final document for a sale of land transaction is deed of assignment. Now, the parties here would change. The parties here are the assignor and the assignee. The parties here are the assignor and the assignee. Assignor and assignee. Now, for preparation of the document, the final document is prepared by the assignee's solicitor, not the assignor solicitor. It's prepared by the assignee solicitor. The final document is prepared by the assignee solicitor. The next issue is to the stamp to be paid. Now, the stamp to be paid for final document is calculated according to the value of the property. That's why it's known as ad valorem, right? The stamp paid at the final document is stamp ad valorem. It's calculated according to the value of the property. And this stamp is paid within 30 days. It is paid within 30 days. So for the fixed one, it's paid within 40 days. And for ad valorem, it's paid within 30 days. So this is the first thing you must demystify in a scenario for sale of land transaction. Then you can go into the 5 stages of sale of land. You must know the 5 stages. It's non-negotiable. You must know 5 stages and the activities in each of the 5 stages. That's the pre-contract stage, the contract stage, the post-contract stage, the completion stage, and the post-completion stage. These are the 5 stages, and you must understand the activities in these 5 stages. So that's for sale of land. Let's get to the third transactions. Yeah, we need to demystify the 4 major transactions today, and I'll leave you and we'll come back next week for another section. Now, the third transaction is lease, L-E-A-S-E. The third transaction is lease. The third one is lease. In lease, I said you should be careful in sale of land. You see, for lease, you should be more careful. In fact, if we can use the word most careful, I know most careful is wrong, but I can say that, permit me, you should be most careful when there is a question on lease. You should be very careful You must, not should, you must be very careful when there's a question on this. The thing is this: lease as a word, L-E-A-S-E, lease in property law practice is used holistically. What do I mean by used holistically? It's used as a word that covers 3 transactions. So when you talk about lease, the lease transaction is 3 in 1. When the law school paints a scenario and you see lease, you must be careful. You don't rush to answer that type of question. When you see lease, the word lease is generally used to refer to 3 transactions. Right? So in quote, in our class, in our master class, we call the lease transaction the Trinity transaction or the tripartite transaction. Remember, in appeal, you must have studied Trinity prayers. So the idea of Trinity prayers in appeal, we use it for lease. So we don't forget that we must apply the technicality in lease in the scenario. When you see lease, L-E-A-S-E, it could be any of the 3 transactions. Lease is 3 in 1. I repeat, lease is 3 in 1. For the last time, lease is used holistically to refer to 3 transactions. That's why you must be very careful. Now, what are these 3 transactions? Number 1, lease. Number 1, lease. Number 2, sublease. I repeat, number 2, sublease. And number 3, tenancy. I repeat again, number 1, lease. Number 2, sublease. Number 3, tenancy. When you see the word lease in a scenario or anything pointing, I will tell you how to identify lease in a scenario now. Anything pointing towards lease transaction, you should not just stop there. You must look further in that scenario to check whether it falls particularly under lease, sublease, or tenancy. Because if you are asked a question, what is the transaction, and you write lease instead of sublease, my friends, you will get that question wrong. And if you write tenancy instead of lease, you would also get the question wrong. And if you write sublease instead of tenancy, you will get the question wrong. This is the issue, application. The problem is not reading. The problem with the bar exam is not reading at all. As a student in the law school, you must read, right? It's not reading. The problem is application of this concept. And that's what we do here at EL Everything Legal. Now, for the lease, I said it's used holistically to refer to 3 transactions. Number 1, lease. Number 2, sublease. Number 3, tenancy. Before we get to this problem, that is how to know whether it's lease or sublease or tenancy, let's get the general idea of lease as it's used holistically. The general idea of lease is that a person creates a term. You would see the word create a term. That creating a term means transfers the interest in land for a certain period of years. So a person creates a term. You see in scenario, Mr. A created a term of 3 years, 4 years in favor of Mr. B. Right? Mr. A created a term of 9 years in favor of First Bank PLC with respect to property situated at number 22 Ghana Street, Maitama, Abuja, right? Or any other way the scenario is painted. Lease as a concept simply means a person transfers interest in land to another person for a number of years. Now, the transfer is not made for free. The person that receives occupation of that land will pay a sum of money known as rent. So the consideration for transfer of a term of years to another person is rent. So this is simply transfer of a term of years from a party to another party for a consideration known as rent. So when a property is given to another person to use the property for 5 years and he's to be paying rent every year, the transaction holistically is lease. That's the general idea you should have. But now let's get to the application, because in property law practice, you must be ready to apply your understanding and demystify this concept of lease in the 3 transactions. The issue is finding out whether the transaction is lease, whether the transaction is sublease, or whether the transaction is tenancy. This is the trinity. This is the 3-in-1 issue you have to deal with in lease. Lease, tenancy, sublease. To identify this, there are 2 factors you must take into consideration in the scenario to identify whether the transaction is lease, sublease, or tenancy. 2 factors you must take into consideration. The first factor is term of years. If you are writing, write term of years. In brackets, write number of years. I advise my students to write number of years so that you don't forget. The first thing you should look out for is the term of years. In other words, the number of years. To break it down more, ask yourself, for how many years was this property transferred to the other party? How many years did Mr. A transfer the property to Mr. B for? The first thing you must identify is the term of years, in bracket, number of years. This is what would make you know that the transaction is lease, sublease, or tenancy. First is term of years, also known as number of years. Then the second is nature of interest. I repeat, the first thing is term of years, and the second thing is nature of interest. Please, when you see this in a scenario, don't rush to answer the question. You must have identified and applied these 2 factors before you answer that question. It is as important as anything. These 2 factors will cost students a lot in the scenario of lease, because a lot of students have not known up till now that the word lease in a scenario refers to 3 transactions, and you must be smart to identify the particular transaction the examiner is testing you on. And there are 2 factors here. The first factor in this is to identify the number of years. In the bar exam, they call it term of years, but I'm telling you now, call it number of years so that you will not forget. The first is the number of years, and the second is the nature of interest. If you started with us in this class, you would have understood the concept of nature of interest, freehold and leasehold interest. So let's begin with term of years first. Then we'll come to nature of interest. Now, in this transaction, the first thing you should do is take cognizance of the term of years, number of years. How many years was the land transferred to Mr. B for, right? Listen carefully. If the number of years, I'm using number of years so you won't forget. If the number of years is 3 years and below 3 years, class, this is a very confusing concept that you must not forget. If the number of years, in fact, I won't use term of years until we finish this list. If the number of years is 3 years and below, I repeat, 3 years and below, 3 years, 2 years, 1 year, 3 years and below, 3 years itself and below 3 years. I know why I'm stressing on this. Even the best of us have to count the number of years to be sure that it's 3 years and below. So if the number of years is up to 3 years, if it's 3 years and downwards, that is, when writing now, you can write 3 years, 2 years, 1 year. So you will not forget. If the number of years is 3 years and below 3 years, 3 years and below. So for 3 years and below, you start counting from 3 years. 3, 2, 1, like that. So for 3 years and below, the transaction is automatically tenancy. I repeat, where the number of years in the scenario, you must underline these things in your scenario. That's why you don't rush to answer questions. For those of us that will be in our revision class, you don't rush to answer questions in the bar exam. You have to understand before you start answering, right? So for 3 years and below 3 years, for 3 years and below 3 years, the transaction is tenancy. For 3 years and below 3 years, where the number of years is 3 years and below, the transaction is tenancy. And I repeat, class, you have no business with nature of interest when the number of years is 3 years and below. Where it is 3 years, 2 years, 1 year, forget about whether the land is covered by certificate of occupancy or not. The transaction is tenancy. The transaction is tenancy. Now, on the other part, if the number of years exceeds 3 years, if the term of years is above 3 years, if the term of years is above 3 years, above 3 years, for above 3 years, we will not count 3. We'll start counting from 4. Listen, above 3 years means we will start counting from 4. So above 3 years, we mean 4 years, 5 years, 6 years, 7 years, and so on. Where the number of years is above 3 years, please, the transaction would be either lease or sublease. Don't rush and write lease. you would easily misfire where the number of years is above 3 years. Where the number of years exceed 3 years, don't be quick to write this. Don't be quick to write this. Please, when the number of years exceeds 3 years, don't be quick to write this. When you see Mr. A created a term of 4 years, 5 years, 6 years in favor of Mr. B, right? The thing is this: you must look at the nature of interest before we establish that the transaction is lease or sublease. I said 2 things now. If it's 3 years and below, the transaction is tenancy. Yes, Faustina said where it is subject to renewal. Even if it's subject to renewal, it is still tenancy. It is still tenancy. If it's subject to renewal, the transaction is still tenancy. Yes. What you should look out for is Mr. A created a term for 3 years. Underline term of 3 years. It points to the fact that the transaction is tenancy. So when you see 3 years and below, the transaction is tenancy. You have no business with nature of interest. But when you see 4, 5, 6 years, where the term or number of years is above 3 years, you must be careful. The transaction may be lease or sublease depending on the nature of interest. This is where nature of interest comes to play. Nature of interest has a role to play here where the number of years exceeds 3 years. Where the number of years exceeds 3 years, you have to find out the nature of interest before you finally write that the transaction is lease. Or if you find out that the transaction is sublease, you write the transaction is sublease. Now, if the land is covered by certificate of occupancy, listen, if the land is covered by certificate of occupancy, it is pointing to leasehold interest. We have gone past that. Where the land is covered by certificate of occupancy, it is pointing towards leasehold interest. So if there is a term of 4, 5, 6, 7 years and above created for a land covered by certificate of occupancy, class, the transaction is sublease. I'll repeat. If the term of years or the number of years is above 3 years, 4, 5, 6, 7, and like that, and the land in question is covered by certificate of occupancy, that's why I say you must identify nature of interest and underline it. If the land is covered by certificate of occupancy and you see 4, 5, 6, 7 years, the transaction is sublease. The transaction is sublease. Please, above 3 years plus certificate of occupancy. I repeat, above 3 years plus land covered by certificate of occupancy equals to sublease. The transaction is sublease. Now, in the scenario, if you don't see certificate of occupancy at all, as I said about nature of interest, you need not stress yourself. Just be looking for certificate of occupancy in the scenario, whether the land is covered by certificate of occupancy or not. Now, if you don't see that the land is covered by certificate of occupancy, if certificate of occupancy is absent and the term of years is above 3 years, 4, 5, 6, 7 years, the transaction is lease. So please, the transaction is lease where the land is not covered by certificate of occupancy. And the transaction is sublease where the land is covered by certificate of occupancy. I'll repeat again. The transaction is lease where the land is not covered by certificate of occupancy. And the transaction is sublease where the land is covered by certificate of occupancy. If you follow and you understand what I've said now, drop that in the comment. I need to be sure that you all are following. Yes, so this is the first thing you must accomplish in a scenario. This is the first war you must fight in a scenario for lease. Don't forget, Trinity transaction. It could refer to any of the 3 transactions, either lease, sublease, or tenancy. To identify which is which, look out for the number of years and what? And the nature of interest. If the number of years is 3 years and below, 3 to 1 year, the transaction is automatically tenancy. Don't stress yourself. Once you see 3 years, be very happy. Go straight to write tenancy. 3 years and below is tenancy. Now, if it exceeds 3 years, where you see 4, 5, 6, 7 years, what you should do is check the scenario. Is this land covered by certificate of occupancy or not? If the land is covered by C of O, yes, the transaction is sublease. Good one, Olamide. Above 3 years plus certificate of occupancy is sublease. And then above 3 years minus C of O is lease. Above 3 years plus C of O is sublease. Above 3 years without certificate of occupancy is lease. This is what you should underline as a smart student. And this would save you a lot in a scenario. It is very important. It's as important as anything. Now we have solved the issue. This is what we have to solve. Now we have solved the issue. Let's quickly run down these 3 transactions inside this. You see why we call it Trinity transaction in our masterclass? Because of this issue. Now, the first one is lease. So if we have successfully identified that the transaction is lease, the parties will be what? The party will be lessor and lessee. The lessor and the lessee. The parties, lessor and lessee. Now, the document to be executed is deed of lease. The document to be executed is what? Deed of lease. The parties, lessor, lessee. The document to be executed, deed of lease. Now, who prepares the document? For preparation of the document, the deed of lease is prepared by the lessor solicitor. The deed of lease is prepared by the lessor solicitor. So where you successfully identify the transaction as lease, the parties, lessor and lessee, the document to be executed, if you don't see document, you see instrument. The document or instrument, deed of lease. And for preparation of the document is prepared by the lessor solicitor. Now, to the second transaction, sublease. When we identify that the transaction is sublease, using this concept and this hack I've given you today, when I identify the transaction is sublease, the next is the parties. The parties will change. The parties now will be the subleasor and subleasee. The parties here are subleasor and subleasee. You can see the danger of not identifying if you get the transaction wrong, you fail the question on parties. You also fail the question on the document to be executed. And the subsequent question will ask you draft. Imagine 4 questions. They start from transaction, parties, document, and draft. And instead of identifying it as sublease, you already picked lease. And the second question says, who are the parties? The 1C said, what's the document to be executed? Then the 1D now says, draft the introductory part of the document you have identified in 1C. You find out that because of this costly mistake, you have missed 4 questions. And this is where students encounter issue in the bar exam. It's not because they don't read. Reading, I keep saying this, reading is not the problem. Everybody reads. Everybody reads. Reading is not the problem. It's concepts like this that make students misfire in the exam. And you come out after the 9 months of hard work, sleepless nights, reading every day, find out that concepts like this have cost you some marks in the bar exam. It's uncalled for. So you need to take the pains to apply, not just read. You must be able to apply. So back to sublease. I said, if the transaction is sublease, the document to be executed is deed of sublease. Deed of sublease, not deed of lease. Deed of sublease. The parties are subleasor and subleasee. The parties, subleasor and subleasee. Now, for preparation of the document, the deed of sublease is prepared by the subleasor's solicitor. I repeat, the deed of sublease is prepared by the subleasor's solicitor. Subleasor's solicitor. So, sublease, the document, deed of sublease, the parties, subleasor, subleasee, and for preparation, it's prepared by the subleasor's solicitor. You can see the trajectory of your questions and how your answers can change. Then for the last one, the third transaction in lease, remember we said 3 in 1. The third one is tenancy. The third one is tenancy. Now, when you successfully identify that the transaction is tenancy, that's when you see 3 years, 2 years, 1 year, the transaction is automatically tenancy. Don't stress yourself. It's automatically tenancy. Now, when you identify the transaction is tenancy, the next thing is the document to be executed or the instrument to be executed. Now, something funny happened last year with my students. We had a class like this and gave a snap test, a question, a task to them on issues in transactions generally to prepare them for the exam. And one of the issues was on lease, tenancy, and all that. A particular student answered the document as deed of tenancy. Yes, because you see, in lease, we had said deed of lease, deed of sublease. So in his mind, it was proper to write deed of sublease because we have been using deed from the onset. But that is wrong, class. That's totally wrong. The reason is this. There's an issue of proper mode of creation. When a lease is created for 3 years and below, listing class. In fact, proper mode of creation is one of the essential elements of a valid lease. If you have read the topic lease, you would remember. Where a lease is created for 3 years and below 3 years, it cannot be created by deed. I'll repeat. Where there is a term for 3 years and below, it cannot be by deed. It is either created in writing or orally. When there is a lease, I'm using this generically now, holistically for the 3 transactions. When there is a lease for below 3 years, 2 years, 1 year, It cannot be created by deed. It cannot be by deed. The proper mode of creation, it must be created in writing or orally. If you don't want to create it in writing, you create orally. And then on the other part, they say where a lease exceeds 3 years, it must be by deed. It must. I did not say will. It must be created by deed. Where the lease is created for 3 years and below, it cannot be by deed. It's created in writing or orally. Now, where a lease exceeds 3 years, where it is 4 years and above, it must be by deed. That's why we started with deed of lease, and we also said deed of sublease. But for tenancy, we can't use the word deed again because it cannot be created by deed following the position of the law. So for tenancy, when you're asked on the document to be executed, you simply write the document is tenancy agreement. The document is tenancy agreement. The tenancy agreement is the document to be executed. So the transaction is tenancy. The document or instrument to be executed is tenancy agreement. Please, not deed of tenancy. Not deed of tenancy. Tenancy agreement. Now, the parties to tenancy transaction are the landlord and the tenant. The landlord and the tenant. Now, a student also asks in past, what if the landlord is a woman? You can write landlord. You would not be marked wrongly for writing landlord where the person is a woman. Yes, yes. So the parties are landlord and tenant. Use landlord, whether male or female. You will not be marked wrongly. Landlord and tenant, right? And the person that prepares the document is the landlord's solicitor. Is the landlord solicitor. So for lease proper, we have lease as a transaction, document, deed of lease, parties, lessor, lessee. Preparation is by the lessor solicitor. For sublease transaction sublease, the document, deed of sublease, parties, sublessor, sublessee, and the preparation is done by the sublessor's solicitor. Now for tenancy, the transaction is tenancy. The document is tenancy agreement. Tenancy agreement. The parties, landlord and tenant. For preparation, it's prepared by the landlord's solicitor. Prepared by the landlord's solicitor. So this is the basic foundation you need in lease. When you have solved this problem, then you go further to the 6 elements of a valid lease. Those certainties: certainty of term, certainty of property, certainty of commencement date and duration, exclusive possession, proper mode of creation. You go to the essential element of a valid lease, and those elements must be in existence. If not, it will render the transaction invalid. Don't forget those elements. And also the locus classicus case of UBA and Tejimola and Sons. Yes, that's a very good case on essential elements of a valid lease. UBA and against Tejimola and Sons. Yes, so basically, these are the key things you need to know in lease. And then, of course, draft. You must draft in property law practice. And for the deed of lease or deed of sublease, you won't be asked to draft everything in the exam. You may just be asked to draft the introductory part or the concluding part, or you'll be asked to draft one clause. So I always stress on this. Drafting is very important. In fact, drafting is more important than citing authorities, than citing cases and sections. Yes. If you understand the position of the law and you're able to apply it, even if you forget the section, you would still be marked correctly. You might not get the complete mark, but you would be marked correctly. You will not fail the bar exam because you did not cite authority. The bulk of the mark comes from the principle and the draft. Yes. The bulk of marks comes from principles and drafts. These are the two things you must master for the bar exam. You can, in course of your reading and understanding, you can pick up and learn authorities, support it with authorities, yes. But for authorities, I will always say this: if you want to be the best graduating student, go extra mile and cite all the authorities you know, right? Now, if in the scenario, if not in the scenario, if during the exam period, it can get overwhelming because it's actually a clustered program. There's a lot to take into your head. And if you can't do with a lot of authorities and sections and cases, it's okay. Just have good knowledge of basic celebrated cases. Like the one I said now, UBA and Tejumola is not a case that you would forget. Section 294 of the Constitution in judgment is not a section that you forget. Cases like Ude and Wara in power of attorney is not a case you forget. Cases like Idehen and Idehen in wills, you will not forget cases like that. Right? We can go on and on. Cases like Dohati and Dohati. You don't need to stress yourself to understand and learn a case like Dohati and Dohati. In course of your reading cases, those celebrated cases come to you, except you experiencing certain difficulties in your reading. But for the exams, go with those celebrated cases and those popular sections. If you want to go the extra mile, I encourage that, good and fine. But so you don't break down. What you are to focus on is on the principle, the position of the law, and then ability to apply them, not just knowing them, ability to apply them. This concept I taught you now, it's just property law. There is more to do in civil. There's something like this we teach in civil. There's something like this we teach in criminal litigation. There's something like this in corporate law. Yes, corporate law that students are always afraid of. Corporate law have techniques in application that if you master, you'll be able to apply them, especially those long procedures. You don't need to cram all those long procedures in corporate law. There are things you can pick out, and you understand those procedures, you're able to apply them. So basically, this is we call it injury time, right? You have a lot to do, so you should be smart about it. Don't bombard yourself with all the authorities. You are not Lord Denny, right? You are not Lord Denny. Yes, I know you want to be Lord Denny, but you are not Lord Denny. Get the basic authorities, that's cases and sections, the basic ones you can get. The ones that will come naturally, they are ones that come naturally to you. Get those ones and go on with your principles and draft. You must draft every day, even on Sundays and public holidays. Yes, you must draft every day, because drafting gives you more mark than even citing authorities. So that's basically the advice come like this. When we have classes like this, we keep on dropping things for you. Now, that's basically for lease transaction. We are done with the third one. We say we identify lease. The last one, and what we'll close our class on, is mortgage. Yes, mortgage transaction. And privately, a lot of you have sent me messages, voice notes, questions. Sir, please, this mortgage is not entering. It has refused to enter. It's too much. It's too complex. It's too technical. So maybe in one of legal lounge sections, we would deal with mortgage in details. But for today, let's have a basic foundation of mortgage. Now, the first problem students have with mortgage is the definition. I'll give you a quick definition of mortgage so that you solve the first issue. This is where the problems start from. Class, mortgage is the transfer of interest in land. Underline interest in land. Mortgage, I repeat, is the transfer of interest in land. In bracket, write legal interest or equitable interest. Follow me closely. Mortgage is the transfer of interest in land. in brackets, write legal interest or equitable interest, close the bracket. Then you continue. To be used as a security for a loan. Mortgage is a transfer of interest in land to be used as a security for a loan with an option of redemption. I repeat, mortgage is a transfer of interest in land to be used as security for a loan with an option of redemption. So there are three basic things you must not forget here. The first thing here is interest in land, and this is where students start having problem. You think mortgage is the transfer of possession. No. Mortgage is not the transfer of possession of land. The transfer of possession of land is the customary transaction pledge, where you give your land and come and stay in my land until I pay you back. That one is pledge. That's not mortgage. This is where students start having problem with mortgage. You start having problem from the definition. And I want you to understand it now. Mortgage is the transfer of interest in land. The first thing you must know is interest. It's interest here that is transferred, not possession. I repeat, it's interest in land that is transferred and not possession. Mortgage is the transfer of interest in land, not possession. That is why one man can use his land to collect loan from three people. If mortgage is the transfer of possession, can three people stay in one property as security for a loan? No, it can't work. So this is the first thing you should establish as student. This is the first problem you students have with mortgage. And this is why you keep sending me questions on mortgage. You have not first deciphered that mortgage is the transfer of interest and not possession. It is not possession of land that is transferred in mortgage. It is interest in land. Now, the interest that is transferred in land may be legal interest or equitable interest. The interest in land may be legal or equitable interest. I would do this for you. I would have something. I would have a separate section. One of our lounge section would be on mortgage. Yes, I will do this for you and also to save myself, so that I don't attend to many questions on the same thing from different persons. Now, I said it's the transfer of interest in land. The interest that can be transferred is legal interest or equitable interest. So Mr. A can hold legal interest as security, and Mr. B holds equitable interest. They are all interested in the same land. In the same land. Mortgage is transfer of interest and not possession. This is the first problem all of you students have with mortgage. Is the transfer of interest in land and not possession of land. Now, this interest in land may be legal or equitable. Legal interest can be transferred, equitable interest can be transferred. Example of when equitable interest can be transferred. Let me take you back to sale of land. Now, in sale of land, at the contract stage, remember, the contract stage, the initial document is executed, right? And the initial document is contract of sale. After preparation and execution of the document, there will be something called exchange of contract. That's where the two parties sign and swap. That's basically exchange. As in the case of DOMB, D-O-M-B, and ISOZ, I-S-O-Z, right? Don't stress yourself with exchange. Exchange is signing and swapping. That's what exchange is, right? That's exchange of contract. Now, when exchange has been done, there are implications. One of the implications of exchange of contracts is that the vendor still retains legal interest, but the purchaser, at this point, he's still a purchaser. The purchaser acquires equitable interest. You can see that the land is not even given to him, but because of the exchange of contract at that contract stage, the purchaser acquires what? Equitable interest. The vendor retains legal interest. Now, at that point, the purchaser can mortgage the equitable interest. At that point, the purchaser can use that land to enter into a mortgage transaction, to take a loan. because he has interest. He has equitable interest, and he can transfer it as security for a loan. So these are the concepts you need to understand. I'm spending more time mortgage because every year I get a lot of questions on mortgage, and I understand mortgage looks technical. Yes, I fully understand mortgage looks technical. We will do that. So this is what mortgage is all about. The interest is transferred to be used as collateral. That's what security is, as collateral for a loan. So instead of using car as collateral, what is used is interest in land. Interest in land is used as collateral for a loan. And it does not end there. There is one more important thing, with an option of redemption. That is when the mortgagor pays back the loan, he can redeem the interest. He redeems interest in land. Yes, he gets back the interest. The interest is transferred back to the mortgagor. Yes. So this is the concept of mortgage. Transfer of interest in land, right, to be used as security for a loan with an option of redemption. After paying back the loan and interest, of course, you must pay with interest. The interest in the mortgagor's land will go back to him, will get back to him. That's called redemption, getting back your interest after settling your debt, settling the loan. That's what redemption is all about. We'll deal with that concept, all these concepts in a separate class. So this is the idea you should have with mortgage, right? And in scenarios, you see basic words that point towards mortgage. Words like facility. Yes, you see facility. You see security. You see loan. You understand? Obtain the loan using social property as security. You see facility. See loan. Right? You can even see assigned his interest to be used as security for a loan. Right? So these are basic words that are pointing to the transaction mortgage. Now, when we've identified the transaction is mortgage, the next is the parties to the mortgage transaction. And the parties are the mortgagor and the mortgagee. Basically, yes, I know there is tripartite mortgage. We'll get to that in a separate class. Now, the parties are mortgagor and mortgagee, except for tripartite mortgage, which we'll discuss separately. The parties are the mortgagor and the mortgagee. Now, the mortgagor is the one seeking for loan and the one transferring interest in land. The mortgagor is the party seeking for loan and the party transferring his interest in land. That is the mortgagor. Then the mortgagee, it ends with GEE. The mortgagee is the party that receives interest in land and also gives out a sum of money as loan. The mortgagee is the giver, the person that gives the money, that borrows the money, right? And then the mortgagor is the borrower, the person that seeks for loan. So you can write something. The mortgagee is always confused by students. Students always mix it up. Who is mortgagor and who is mortgagee. So I'll help you to do this by remembering the last three words of the last three alphabets, of both mortgagor and mortgagee. So for mortgagor, it ends with GOR. So you can write underneath that GOR means to beg. GOR hyphen to beg. So you know it's the one begging. The ones that end with GOR, mortgagor, is the one begging for loan. So GOR means to beg. Then GEE, right under it, GEE means to give. So when it ends with GEE, it is the person giving. And then when it ends with GOR, is the person begging. So GOR means to beg, GEE means to give. So when you get this, you will find out that the mortgagor is the party that seeks for loan and transfers his interest. Now, the mortgagee, GEE, is the party that gives the loan and receives the interest of the mortgagor. So these are the parties, mortgagor and mortgagee. Yes, and mortgagor will come first. It is between the mortgagor and the mortgagee, because it's the mortgagor that is transferring the interest in land between the mortgagor and the mortgagee, right? So the parties, mortgagor and mortgagee, say for tripartite mortgage, which we will deal with in another class. And then finally, the document to be executed is deed of mortgage. The document to be executed is deed of mortgage. However, we would also find out that there are instances where you would not need to execute a deed. That's for equitable mortgage. For equitable mortgage, deed is not required. But for legal mortgage, it must be by deed. So generally, the document is deed of mortgage. The document is deed of mortgage. Now, for preparation of the document, the deed of mortgage is prepared by the mortgagee's solicitor. The deed of mortgage is prepared by the mortgagee's solicitor. It is the mortgagee's solicitor because the mortgagee solicitor is the mortgagee, rather, is the risk bearer. It's his money that is at stake. It's the mortgagee that is giving money for a certain period of time, right? So it makes sense that the mortgagee solicitor prepares the document so he protects the interest of the party at risk. And this not even to cheat the mortgagor, because the mortgagor has his own solicitor who will review the deed of mortgage before it is executed, that's signed, sealed, and delivered, and all that. So the preparation, don't forget, class, the deed of mortgage is prepared by the mortgagee's solicitor. By the mortgagee's solicitor. By the mortgagee's solicitor. At this point, we have dealt with what I planned for you today, giving you a foundation in property law practice and examining transactions. You would see transaction in the scenario. Now for bonus, please, wills is not a transaction. I repeat, will is not a transaction. Probate is not a transaction. When it comes to will and administration of estates, they are not transactions. Don't write the transaction is will. Will is not a transaction. Probate is not a transaction, please. Wills and administration of estate, matters and administration of estate, they are not transactions. Although that's another important aspect of property law practice. After these 4 transactions, you have to also understand wills and administration of estate. And as a final bonus, there's a relationship in wills and administration of estates that cut across the 3 topics you'll be learning in wills and administration of estates. This is the relationship of how a property passes from a man who is deceased to another person that is alive. How the property of the deceased pass, or how a person that is alive gets the property of a dead person. There are 3 stages here, and these 3 stages cut across the topics you'll be learning in administration of estate issues. The first one is will. So the person, the deceased, must have executed a will. If there is no will, there's another way out. Yes, we'll get to that. The deceased person must have executed a will. Now, in that will, the deceased person must have appointed persons to manage his property. I repeat, the deceased person must have appointed persons to manage his properties, and the deceased person must have given instructions as to the persons that will get the property. These persons are known as beneficiary. So 2 things happen in a will. In a will, the deceased in his will have divided his property to beneficiaries. The deceased, also in his will, had appointed persons to manage the property and finally hand over the property to the beneficiaries. These persons appointed to manage the property are known as executors. I repeat, they are known as executors. So the first topic is will. So in will, you will learn how a man can give instruction as to who gets what in his property, and also give instruction and appoint persons that are to manage his property at the point of death, after his death. Now, the persons appointed, the executors, would have to obtain an authority to act. Yes, they were appointed in the will, but they cannot act on the property without authority. Please understand this. These executors, even though appointed, cannot act on the property of the deceased without authority. And this authority to act is known as probate. This is why you would learn probate practice as the second topic. So the executors must apply and obtain probate from the probate registry. And it is the probate that gives the license, the authority to manage the property of the deceased. Even though they are appointed, they won't go straight to the property without obtaining this authority known as probate. That's why there is something called executor disjunctor, where an executor manages the property of the deceased without obtaining probate is known as executor disjunctor. So he's liable. He's liable, and there are basic liabilities of executor disjunctor. We can't get into that in this class. This is an introduction. Now the executor must obtain authority to act, and this authority to manage the property is known as probate. After obtaining probate, the property will not just get to the beneficiary, depending on the location. Yes, depending on the location. There is one more topic you must, and that topic is assent. Now, the executors who have obtained probate and managed the property, settled all disputes in the property, made all payments, if the deceased person was owing, settled all the debtors and all that. After all the management and administration of the estate of the deceased, for the title to pass to the beneficiary in certain locations, that's why I said location is important. In certain locations, the executors must what? Prepare a document known as assent. So it's this assent that passes the title to the beneficiary. So the chain of how a property gets from a property of the deceased gets to a living person starts from will, followed by probate, the authority to act, and then the executors would execute a document known as assent. Now it is assent that passes title to the beneficiary. That is why if you look at the root of title, assent is classified as a good root of title, because assent passes title in the property to the beneficiary. But will is not a good root of title. Will is a document that have instructions. Will does not pass title. What is contained in will is instructions. So what passes title is assent. That's why assent is a good root of title, but will is not a good root of title. So these are basic issues in wills and administration of estates. Now, if the person dies intestate, dies without a will, there is a way out. The administrators would also go to the probate registry and obtain authority. And that authority to act is known as letter of administration. So we obtain probate where the deceased died testate with a will. And then we obtain letter of administration where the deceased died without a will. The deceased died intestate. So even if there's no will, there's a way out. Approach the probate registry, apply and obtain letter of administration. With letter of administration, the administrators can act on the property of the deceased, and they would not be liable as executors the son taught. Take note of that. So these are basic issues in property law practice. These are introduction to Legal Lounge, a free platform where we assist students, aspirants to the bar to both understand and apply these concepts in succeeding in the bar exam. Our pleasure is that you succeed in the bar exam and they are called to the Nigerian bar. When you are called to bar, the sky is your starting point. You see, the license to law is a very beautiful profession. Why I say this is when called to bar, you are given an open check. It's in your hands to achieve what you want to achieve. You can go any length, you can make any amount of money, you can be anything you want to be as a lawyer. When you get called to bar, you have a license to practice law in Nigeria, in any area you so wish. And you are at liberty to source for your clients. You are at liberty to grow, to learn from seniors, get good at certain areas, and also grow in certain fields and become an authority. So the sky is your starting point. That's why you must focus and make the best out of what you can at the law school and be called to bar. What I want to hear is that you are called to bar. That will be our pleasure and that will make us happy. So yes, Olamide said, I really appreciate your kind gesture. Yes, you are welcome. You are welcome. God bless you too. So having said all that, this is the first section on Legal Lounge, our night section to prepare you for the bar exam. Free of charge, totally free of charge. So we'll be back here next week, Saturday, by 7 p.m. Have a good evening. I am Chukwemeka Philip Esq, and this is EL Everything Legal.